So you found the perfect partner, but they disappeared during a lawsuit, want half the profits forever, or start controlling the company. I've seen founders lose six figures and their business just because of one signature. In this episode, I'm breaking down the biggest mistakes healthcare entrepreneurs make when choosing their partners and how to avoid losing your clinic, your cash, and your control. Stay till the end, and I'll show you the one legal document that would have saved them all. I have a great example of this. So there's a medical spa. There were two owners, both nurse practitioners. They both came into our office, and we were actually working on other stuff for them. We were working on good old compliance and hiring employees. Turns out, fast forward a few months, we came to learn that they had no ownership agreement. And actually behind the scenes, there was a dispute that was rumbling that we only came to learn from when they both brought it to our attention. And so it turns out that they had run a very successful business. They were doing millions in revenue a year, hiring employees. They had done everything right. Their structure was perfect, but they had no prenup and no legal agreement. And so two things were happening. First, there was a minor board investigation, and there was a dispute as to over whether it was one owner or the other. Okay, so that was going. Also, there was a lot of money moving around. And one of the owners was perhaps doing a little bit more than the other on a day-to-day basis, and they'd never had the conversation or put really anything in writing as to what their roles were going to be once the company got to this level. And so a number of lessons can be learned from this scenario, because what ended up happening is they ended up both lawyering up, not with our office, with other lawyers, and I suspect spent tens of thousands of dollars and also time and energy away from the business resolving that, when they could have been focused on the business itself, or simply have spent a few $1,000s, if that, to have the prenup that said what they do in the case of a dispute and in the case of a board investigation, or what the roles were supposed to be of each individual. So learning points from this: one, get a prenup, pretty easy. The business prenup, the ownership agreement, the shareholder agreement, the member control interest, whatever it is called in your respective state, you need one of those. At a bare minimum, get something down in writing that says, what are the roles? What are the people's buy-ins going to be at the beginning, whether that's time, money, something else? What's going to happen if there is a dispute, a board investigation, if one of the owners wants to leave? All of that could be in the ownership agreement. And so that's number one. Number two is, let's have the tough conversations on the front end, even if the company isn't worth that much, so that we have something in place and we're not trying to figure that out on the fly on the back end when there's a lot of money on the line. I also think it's a lot easier to do it on the front end, because you're taking things seriously. You're having the tough conversations, even though you may not have $1 million right behind those decisions now. We can always amend and change an ownership agreement if you're being smart with your attorney in the future, but we can't magically make one come into thin air. And so those are going to be the two big things. Otherwise, you're just going to default to who has the most money to hire an attorney and what does the common law of the state actually say about a business relationship. And that is absolutely not what you want. Also, the Healthcare Licensing Board does not care what the ownership is. They're going to go after anyone they can get their hands on, both from public filings as well as who is acting like they have ownership over the company. And if they have a license, a healthcare license, they will simply do an investigation on anyone who they think is involved and has touched any of the files. Now, what would have been nice is if there was an ownership document, we would be on the same team and provide a nice joint response to those boards. What can happen is when we don't have that and the board is sending out 1, 2, 3, or 10 different investigations, now we're in a fractured battle with the board. And sometimes we might even be sharing information we probably didn't have to or shouldn't in order to get a different partner in trouble. So you can see how not having the prenup at the very beginning, the business prenup, is absolutely going to lead to issues the further down the road that you get. Now that we've seen what goes wrong, let's break down what the law actually says about ownership. First, let me ask you a question. Have you liked and subscribed to the David Holt Show? Well, make sure you do that. My next question. Have you ever tried to talk to someone who spoke a different language? It doesn't work, right? You need a translator. So, for an ownership situation, not everyone thinks of ownership as the same thing because they're actually speaking different languages. That's where a translator comes in. So allow me to be your translator for the next few minutes. What a good business attorney should be able to do is to be able to have two or more different people agree on one definition of ownership and what that actually means. And that does include all of the nuances of voting and liability and risk, but really explaining that to the sophistication level of the actual owner or owners. I've worked with some clients that are venture capitalists, VCs, they're raising money. They are going to fixate and focus on exit provisions and where the money really affects them. I've worked with a lot of first-time business owners, and they're just acknowledging that they're even a business owner in the first place, and we got to dispel a lot of the myths about ownership and actually educate them on how this is going to work. And one thing that I think a good business attorney is really useful for is facilitating some of the tough conversations right out of the get-go, but doing it in a very non-threatening way so that we can get to an agreement that we feel good about and we can move forward and feel strong about, hey, we can navigate a dispute. We know what's going to happen if there's a board complaint. We know what's going to happen when we need to vote about something. Is it just via email and a little bit more informal? Or do we want to actually sit down and write down meeting minutes and things like that? Both are generally okay as long as we agree to that in the ownership agreement. So in addition to that, what the ownership agreement is going to talk about is who can actually be an owner in the first place. And state law in most states actually restricts unlicensed individuals or people from actually being owners of professional corporations or companies. And this is largely because of the corporate practice of medicine doctrine. We don't want unlicensed people influencing the medical judgment of the doctors, nurses, and other medical professionals. And so the first thing right out of the get-go is just figuring out who's in and who's out, right? And there may be some restrictions based on who's in and who's out. One other thing I want to talk about is different types of owners in general and some of the myths I've heard over the years. And so I own stocks. I own stocks today in publicly traded companies. I'm technically a little micro owner of those companies, and it's fun to watch, but I don't really do anything. I've just put my money, I've parked it out, and the company does what they have with it. I'm largely, you could say, a silent owner. I don't do anything on day-to-day operations, but if the company does well, I make money, and I might leave as an owner of those stock, cash out. That's okay. That's one type of owner. Another type of owner is going to be much more hands-on. It might be more of a sweat equity type owner, a stock option. So a lot of their value is derived from them just sticking around and doing actual work and labor and not just inserting money, taking money out, which is very important. Those are two very different types of owners, but oftentimes, especially on a new healthcare company, we don't have the conversations about what people are bringing in and how they can actually get out. And so this is when things like a silent partner or silent owner can become dangerous because they've come in under the assumption that they're bringing money to the table and that's it. But the other owners are coming in expecting that not only are they going to bring money in, but they're actually going to do stuff. And so there's a lot of stuff that's left undone because we never had the conversation about who's going to do it. And I don't know if you've ever had roommates or you've been with a family and you never talk about how to actually clean the house, right? Never gets done. But you finally have the conversation, you put up a little chore chart or you get some sort of organizational system and it actually gets done. Imagine walking into a household with a bunch of roommates, maybe you know the roommates a little bit, but if it was like me back in college, the place was just a disaster. It's just a pigsty because no one actually had the conversation about who is going to do what. Finally, it becomes so disgusting that you finally have to have that conversation. But that would be an assumption that some of us probably brought into that roommate relationship or similar to an ownership situation as to, well, these were just going to kind of get done and I never really thought about it until it became more of an issue to do. So very similarly, that's the approach that we're going to take when we're thinking about ownership. So how do you protect yourself? Let's look at what smart founders do before they ever sign a deal. So I actually had somebody that came to us with about a one-page agreement, and they thought it did something. It actually did the exact opposite. They actually thought that it was making them a majority shareholder, where in fact, it had actually stripped them of a lot of their rights. Now, if there's one thing that you can get out of this podcast, it's that you need something in writing. If you don't have anything in writing, an ownership agreement, it can be called an operating agreement, a shareholder agreement, it depends on your state and structure, but let's just call it an ownership agreement. And funny enough, I actually have a really good resource for you. Down in the link and in and on our website, we have a good resource for how, at a bare minimum, the things you should be asking and doing when you're drafting an ownership agreement that I really encourage you to use. In fact, I've even drafted it so that it's healthcare specific, so that when you're in the healthcare industry, you're hitting some of the little nuanced things that happen in an ownership agreement. But in closing here, let's just talk about what it would look like if I didn't have an ownership agreement. The analogy would be this. It would be like two people trying to put a puzzle together, but they actually don't have any of the idea of what the puzzle is supposed to look like. And then a third party, somebody else comes in, the judge in this case, and they simply get to decide what the picture is. And they're going to look at how you behave. They're going to look at maybe texts and emails, and it's going to be ugly and messy. And you're probably never going to agree with what their decision is. But absent that written agreement, that's what you're going to get. It's just going to be a hodgepodge of someone else creating your own puzzle that the two of you were trying to make. Where the business attorney really comes in is how to make this ownership structure in the relationship smart, fair, legal, and future-proof. And that's where the business attorney comes in. I'll leave you with this. If you don't have a prenup in your marriage, you're probably in love, and that's okay. If you don't have a prenup in business, you're probably a beginner. So to help keep you from feeling like you're behind, make sure to download that ownership agreement, which I've left for you, linked below in the show notes. If you think partner problems are bad, just wait till you hire someone and accidentally turn them into an employee. Next time, we're talking about nurse practitioners and the hiring mistake that gets more clinics sued than you'd believe. You're going to want to watch that one before you post the job.